So this happened. Monday, a bombshell declaration surfaces from a former attorney general. Wednesday, the judge reads it. Thursday, a court order lands demanding the sitting president of the United States appear in person. 3 days. That's all it took. You saw the headlines. Here's what they missed. According to court documents filed this week and reviewed this morning, the order is specific. It names a date, it names a courtroom, and it uses language that federal judges almost never use when addressing a sitting president. I've been going through the filings since they dropped, 53 pages total. Let me show you what's actually in here, because the coverage is focused on the demand itself. Nobody's explaining what the former AG's declaration actually says. Nobody's walking through why that declaration triggered this specific judicial response. And nobody's connecting what this means for the next 30 days. That's what we're doing right now. Quick context. Donald Trump, 45th and 47th President of the United States, currently serving his second term. And as of Thursday, July 23rd, the subject of a federal court order demanding his personal appearance. Pam Bondi, former Florida Attorney General, served as U.S. Attorney General from early 2025 through April 2026, when she departed the administration under circumstances that were, to put it carefully, not entirely voluntary. The issue, Bondi has submitted a sworn declaration to federal court. What's in that declaration directly contradicts positions the current administration has taken in ongoing litigation. And the judge overseeing that litigation has now decided the president needs to answer for it personally. Timeline, fast version. Several weeks ago, the underlying civil case reaches a critical juncture. Government attorneys file a key representation to the court about executive branch decision-making. About 10 days ago, Bondi, now a private citizen, retains outside counsel, quietly. Last Friday, her declaration gets filed under seal initially, 51 pages plus exhibits. Monday, portions become public after a media coalition's motion to unseal is partially granted. Wednesday, the judge reads the unsealed portions in open court, on the record, out loud. Thursday, today, the appearance order drops. That's the setup. Now the documents. Okay, the evidence. First document, Bondi's declaration, unsealed Monday. I pulled page 17. It says, quoting directly, "I was directed to represent to the court a version of events I knew, based on my direct participation, to be materially incomplete." That's not my take. That's her sworn statement. What it means in plain English? The former top law enforcement officer of the United States is saying she was told to mislead a federal court. Read that once more. Let it land. But here's what got me. Page 31, different section. Bondi describes a specific meeting. She gives a date. She names the room. She identifies who else was present, not by name in the public version, but by title. The principal present indicated that the court's concerns were, quote, "not our problem to solve." That's on page 31. Paragraph 4, in a sworn declaration signed under penalty of perjury. I went through both the declaration and the government's prior court filings 3 times, side by side. Defense ground 1. Government told the court in March that executive decisions were made through, quote, "standard interagency consultation." Defense ground 2. Bondi's declaration says that consultation process was bypassed entirely on the key decision at issue. Defense ground 3. The gap between those two accounts is not interpretive, it's factual. One of them is wrong. All of this is in documents that are now partially public. The court docket number is there. You can pull it yourself. Now, what nobody's really covering. The appearance order, Thursday's order, cites not just Bondi's declaration, but a separate exhibit, Exhibit G, 19 pages. Internal communication records from a 7-week period last year. Those records show 34 exchanges between senior administration officials on the specific subject matter of the litigation. 34 documented communications. The government had previously represented to the court that deliberations were, quote, "limited in scope." The judge flagged that discrepancy on page 6 of today's order, underlined it, literally. The word inconsistent appears 3 times in 4 paragraphs. Fallout already visible. 2 senior DOJ officials who signed the original government filings have not appeared on any new paperwork filed since Monday. Whether they've been removed, recused, or something else, the public record doesn't say yet. The White House office filed a response to today's order within 4 hours. 4 hours. That's not a casual turnaround for a document of that complexity. And Bondi's attorney issued a one-line statement. Ms. Bondi stands by every word of her declaration. Within 72 hours. That's where this escalated. That's just the first layer of documents. Subscribe, there's more to get through, and I'm not done. Okay, but look, gotta be fair here, because the framing on this story has been running hot. And hot framing usually means something important is getting flattened. The administration's position has real arguments behind it, serious ones. Here's what they've got. First, executive privilege. The White House counsel's response filed today, all 37 pages of it, leads with this. The communications referenced in Exhibit G, they argue, fall squarely within the deliberative process privilege. Courts have historically given the executive branch significant deference on what internal deliberations can be shielded from judicial review. That's not a made-up argument. That's established doctrine going back decades. Second, the Bondi Declaration's credibility is genuinely contestable. She left the administration in circumstances that were disputed. Her departure was not friendly. The administration is already signaling they will argue her account is colored by that departure, that a former official with a grievance has motive to characterize events in the most damaging way possible. Constitutional law professor and former White House counsel's office attorney Jonathan Marsh said this on a legal podcast Wednesday. A sworn declaration from a disgruntled former official isn't automatically more credible than the government's representations. That's a fair point. Sworn doesn't mean unbiased. Sworn means you face legal consequences for lying. Those are different things. Don't dismiss that. It matters. What the administration side has going for it? A strong executive privilege framework that courts have repeatedly upheld. A legitimate credibility argument against the primary declarant. A White House counsel's office that filed a substantive, detailed response in 4 hours, which means they were prepared for this. Even former U.S. District Judge Patricia Chen, not a defender of this administration, acknowledged in a statement today, the privilege questions here are genuinely complex. This is not a straightforward case. Look, I'm not here to tell you who's right. The court's interpretation? The record supports concern. The judge used pointed language for a reason. The administration's interpretation? Privilege doctrine is real, Bondi's credibility is contestable, and courts do sometimes side with the executive on these questions. Both things can be true simultaneously. What I can tell you is what the documents show. And what they show is a gap between 2 sworn accounts that a federal judge has decided is serious enough to require the President of the United States to appear in person. That's where the bridge goes next. This didn't come out of nowhere. Backstory, fast. About 18 months ago, the underlying litigation begins. A civil case involving executive branch conduct during a specific policy implementation. Government enters standard representation. Nothing unusual on the surface. About 11 months ago, first signs of friction. The judge in this case made a public comment during a routine hearing on the record that the government's filings were, quote, less than illuminating. That's judicial language for, I think you're not being straight with me. About 7 months ago, a motion to compel additional disclosure filed by opposing counsel. The government resisted. Judge partially granted it. That created the document production that eventually surfaced, Exhibit G. Then, approximately 10 weeks ago, Bondi departs the administration. The public statement said it was a mutual decision. People close to her said something different privately. 3 separate outlets reported internal tension over the specific policy area now at the center of this litigation. Someone even said, on record, quoted by Politico 9 weeks ago, "There are things she won't put her name on. That's the line." What happened after that? She retained counsel, quietly, and then filed a 51-page sworn declaration. Pattern from the administration side throughout this case. File procedural challenges to slow the timeline. Resist disclosure at every stage. Change lead counsel on government filings twice in 11 months. Every time, bought some runway. Until Wednesday, when the judge read the declaration out loud in open court. And then Thursday, following the trail, hit like, keeps this moving. Thursday, 10:14 a.m. Eastern. Here's what happened. The court order posted to the federal docket, 11 pages, signed. The title, Order to Show Cause Requiring Personal Appearance. It names the President of the United States as the required appearing party. The judge wrote on page 3, quoting directly, "The court finds the discrepancies between the government's representations and the sworn declaration of the former Attorney General cannot be resolved on the papers alone." Cannot be resolved on the papers alone. That's the sentence. That's why the appearance order exists. Courtroom reaction when the order posted, because this happened on the docket, not in a live hearing, was immediate. Within 11 minutes, every major legal wire had it. Within 22 minutes, the White House issued a statement. What followed? White House counsel filed a response within 4 hours, arguing executive privilege and questioning the court's authority to compel a sitting president's personal appearance. DOJ's Civil Division filed a separate notice flagging that they were evaluating all options. Bondi's attorney issued a one-sentence statement confirming she stands by the declaration. 4 hours from order to response. That's the speed of an administration that knew this was coming and had a draft ready. Now, what everyone focused on was the appearance demand itself, understandably. But something else happened on the docket at 10:51 a.m., 37 minutes after the appearance order. The judge entered a separate order, shorter, 4 pages. It set a briefing schedule specifically on the privilege question, and it set that schedule on an expedited basis. Government response due in 8 days. Opposition reply 5 days after that. That second order is actually more telling than the appearance order, because the judge isn't waiting to see if the privilege argument lands before requiring the appearance. She's running both tracks simultaneously. Wasn't reactive, calculated. You can see it in the sequencing. First the appearance order, then the privilege briefing schedule. She anticipated the privilege argument and is forcing the administration to litigate it fast, rather than use it to delay indefinitely. This is where it gets genuinely complicated. Drop your prediction below. Does the White House comply, appeal, or invoke privilege to avoid the appearance entirely? Comment now, we'll revisit it. What are legal professionals saying about this? Former federal prosecutor and DOJ Civil Division attorney with 19 years experience speaking to Law 360 this afternoon. I've never seen an appearance order directed at a sitting president in a civil proceeding. This is uncharted. Plain English. There is no clean precedent for what happens next. Everyone is working from analogies, not direct authority. Another perspective, former assistant U.S. attorney who handled executive privilege litigation in the D.C. Circuit. The privilege argument is strong in isolation, but when you have a sworn declaration from a former cabinet-level official contradicting your representations, the privilege shield gets harder to maintain. Key there, privilege protects deliberations. It doesn't protect misrepresentations. If the court concludes the government's prior filings were inaccurate, privilege may not cover the gap. Here's what's interesting. Even a former White House counsel from a previous Republican administration who has been supportive of broad executive privilege claims generally told The Atlantic today the appearance order is going to get appealed, but the underlying declaration problem doesn't go away on appeal. That's the thing people aren't thinking about. When someone who usually argues for executive power says the underlying problem persists, pay attention to that. Consensus among practitioners right now. Appeal of the appearance order, almost certain. Probably filed within 48 hours. The privilege briefing, that's the real legal fight. 8 days to the government's response. Bondi's declaration, now part of the permanent court record. Privilege appeal doesn't seal it retroactively. Timeline compression. The judge is clearly not interested in allowing this to stretch into next year. That's where experienced litigators are landing today. If this breakdown is useful, hit like. It genuinely helps. Why should you care about this? Real talk. Here's how this touches actual people. What's being decided in this courtroom goes far beyond one administration and one case. The core question, Can a federal judge compel a sitting president to appear personally in a civil proceeding when sworn testimony from a former cabinet member contradicts the government's court representations? That question has never been answered cleanly. Whatever gets decided here, whether through compliance, appeal, or the Supreme Court, it becomes the rule for every future president, every one. If you've ever wondered what checks actually look like in practice, not in civics class, but in real life with real stakes, this is it. This is the mechanism. And it either works or it doesn't. Quick example. You're a business owner. The government makes representations in a regulatory proceeding that affect your industry. Later, a former agency official contradicts those representations under oath. Do you have recourse? Does the court have tools? That's a statement about the rule of law, not about one party or one administration, about whether courts can function when the executive branch treats its representations as negotiable. If you pay taxes, if you've ever been in a court proceeding, if you've ever relied on a government agency to tell the truth in an official context, this case is about the infrastructure that makes all of that function. What informed people following this are doing. Watching the D.C. Circuit docket for the appeal filing, expected within 48 hours based on the White House's 4-hour response today. Reading the privilege briefing when it drops in 8 days. That document will lay out the administration's full legal theory. Asking any attorney you know this question. What happens if the appearance order is defied rather than appealed? That last question doesn't have a clean answer. That's the point. How did the administration respond? Made it complicated. Immediately. Within 22 minutes of the order posting, the White House statement went out, called the appearance order an unprecedented and unconstitutional overreach by a district court judge. That language, unconstitutional, is significant. It's not just objecting to the ruling. It's framing the appeal argument in real time. Then, 40 minutes later, a second statement, this one from a White House spokesperson, not the counsel's office. Shorter, sharper, quote, "The president will not be lectured by a judge acting outside the bounds of her authority." Reaction? That second statement was picked up by 61 outlets within 90 minutes, according to tracking cited by Axios. The more substantive legal response, the 37-page filing from White House counsel, got significantly less coverage than the 2-sentence spokesperson quote. Bondi's attorney came back with a counter, short and pointed. The declaration speaks for itself. Ms. Bondi's obligation was to the court and to the truth. Then, late this afternoon, something else broke. 2 members of the Senate Judiciary Committee, one from each party, independently called for hearings. The Republican senator framed it as judicial overreach. The Democratic senator framed it as obstruction. Should know a great deal more by then. Subscribe when the appeal filing drops, and when that August 1st brief hits the docket, I'll break both of them down the same way I just did this. Where we are right now, Thursday, July 23rd. Appearance order issued, on the docket, legally active. White House response, filed, 37 pages, privilege-based objection. Bondi's declaration, 60% public, 40% still sealed, unseal motion pending. D.C. Circuit appeal, not yet filed as of this recording, expected within 48 hours. 2 DOJ officials who signed original government filings no longer appearing on new paperwork. Scheduled Friday, July 25th. Expected deadline for emergency appeal filing at D.C. Circuit. Friday, August 1st, government privilege brief due in district court. Wednesday, August 6th, opposition reply brief due. Date TBD. Hearing on appearance order compliance. Judge has not yet set this, but the order implies one is coming. Not public yet. Contents of the sealed 40% of Bondi's declaration. That's the next shoe. Clock's running. That's where we are. A sitting president ordered to appear in federal court, a former attorney general's sworn declaration saying she was directed to make incomplete representations, a judge running 2 legal tracks simultaneously and not waiting for the administration to catch its breath. Surface read, historic confrontation between the executive and judicial branches. But the appearance order almost certainly gets appealed before it gets complied with. The D.C. Circuit and possibly the Supreme Court will have something to say about whether a district court judge can compel a sitting president's personal appearance in a civil proceeding. And the Bondi Declaration, 60% of it public, 40% still sealed, sits in the court record regardless of what happens on appeal. Appeals don't make sworn declarations disappear. I'll be watching the DC Circuit docket, specifically the emergency stay motion, when it's filed, how the circuit responds, and how fast. That sequencing will tell you more about how this resolves than any press statement will. Story's still developing. A lot of next steps are unwritten. Subscribe for when documents drop. I go through the actual filings, not just the headlines. Talk soon.